Yes, Dean of Faculty.
I'm obliged, my Lords. I was referring to the requirement for expert determination as required in terms of Clause 5 of Part 3 to the schedule, which can be found in the Core Bundle Volume 1 at page 295. And if we look at 5.2 at page 294, we can see that the intention is that the accountant shall act as an expert and not as an arbitrator in the matter referred to them for determination. And as was noted earlier, the tonnage audit, which is then to be carried out, means the external verification of the tonnage. So whatever the parties may or may not have contemplated they were willing to do by consent, they have moved beyond that, and there is to be an expert determination. And that has been expressly at the request of Inveresk. Now, on the role of the expert in that context, I wonder if I might just refer your Lordship shortly to two cases from the inner house of the Court of Session. First of all, MacDonald Estates against NCP, which your Lordships will find in Volume 3 of the Bundle of Authorities at tab 52. Volume 3 is the small volume, my Lords. Tab 52. It is a decision of the extra division of the inner house affirming a decision of Lord Hodge, the Lord Ordinary, and the opinion of the inner house was delivered by Lord Reid. To go shortly to the head note, an independent expert acting under a contract relating to the proposed development of a car park was appointed to determine whether or not a suspensive condition which related to the acquisition of satisfactory planning permission had been purified. The contract was contained in detailed legal missives and comprised a relatively tight timetable for the purification of the suspensive condition and provided that on the expiry of the time allowed, either party could resile from the contract. The parties to the contract disputed whether the agreement under which the expert was acting was one to refer to arbitration within the meaning of Section 3 of the 1972 Act, with the consequence that he could be required to state a case for the opinion of the court. The independent expert decided that he was acting as an arbiter, and that decision was challenged by way of an application for judicial review. And it was held that the express wording of the contract made it clear that the parties had no intention to refer a dispute or disagreement to arbitration, and that the procedure upon which they had agreed was one of expert determination. And if I can refer your Lordships to...
Just before you do, could you help me as to the relevance of this question, as to whether it's an arbitration or a expert determination? Why does this arise in this case?
Because of the position adopted by Inveresk, albeit not entirely consistently, that the only issue under Clause 5 for the accountant to perform was to adjudicate between their competing positions, namely the draft accounts on the one hand and the adjustments on the other. And that was the argument advanced before Lord Glennie, and which he essentially agreed with. And it led on to Inveresk arguing that there was no implied right on the part of Tullis Russell to withdraw or adjust the draft consideration accounts so that they were left with them, and if and when Inveresk chose to abandon, as they at one point put it, their adjustments, there was nothing for the expert to do, with the consequence that Clause 5 couldn't operate, and by implication, because there's no express provision for this, a payment date did arise in respect of the sum fixed in the original draft consideration accounts.
Well, not entirely sure I follow that. your submission is what? That it is an expert determination, not an arbitration, and the thing to be determined is the tonnage.
Precisely so.
But I mean, you could have had an arbitration about the tonnage if you wanted to.
But
So that's why I'm not quite sure why it matters.
Well, simply because the expert's determination is not open to challenge on the same grounds as, for example, an arbiter's decision would be. He's not required to state a case for the opinion of the court.
But why should that make any difference?
Well, at the end of the day, my lord, in the context of an arbitration, it was suggested that Clause 5 was supposed to operate as a dispute resolution process, determining the difference between the figure advanced by Tullis Russell and the figure advanced by Inveresk. Now, I don't suggest for a moment that's right.
But I'm sorry to interrupt, but again, you can describe the expert determination as a dispute resolution method, just like arbitration is, or indeed mediation is. That the question is what is to be determined.
Indeed so.
And at the moment, I can't see why the answer to the question differs as to whether you treat this as an arbitration or an expert determination.
Well, my lord, the reason why it appeared to matter in the eyes not only of Inveresk but the inner house was this. It was argued by Inveresk that what was actually for determination by the expert, or call them what you will, was whether the draft consideration account should be accepted or whether the adjustments to the draft consideration account should be accepted. And we, Tullis Russell, submitted that that was not correct. Once the matter of an expert determination was triggered, it had to be an external verification of the tonnage, and just that. And it may well be that the expert would arrive at a decision quite different to that contained or expressed in the draft consideration accounts or in the adjustments thereto. Now, that may then have implications for the argument that was advanced by Inveresk initially that they could waive the requirement for expert determination, or that they were entitled to, as they put it, abandon the request for expert determination once it had been made, because they argued that it was conceived only for their benefit because it was directed only to adjusting away from the figure in the original draft consideration account.
Sorry.
No, please.
No, I was just going to ask, where does the inner house deal with this point?
Yes, if I can come back...
If it matters at all.
Well, it's a very short point, my lord, but if I can take the lords to it, the paragraphs 26 and 27... And this is in the inner house opinion, which begins at page 47, and the relevant passage is very short and is to be found at page 15.
Are we looking at the case you've just cited, or the inner house in this case?
The case I've just cited.
Oh, I'm sorry, I was meaning this case.
I'm a cross person.
Yes, I just wondered whether, where did it, since it's supposedly relevant, where do we find Lord Clark dealing with that?
We can find out if we go to tab 2.
Got that, whereabouts?
It's page...
At page 19 of tab 2.
Yes, it's the paragraph...
And it's paragraph 22, although it's a very long paragraph.
Trouble, that's why I couldn't find it.
It's a very long paragraph, and it's the latter part of it. The pagination from the core bundle is 19, and a quarter of the way down, the opinion of the court delivered by Lord Clark was in these terms. If the proposed adjustments to the consideration accounts cannot be agreed, then a tonnage audit takes place to verify and confirm the figure first proposed in the draft consideration accounts. Well, in my respectful submission, that's not the purpose of the expert determination at all.
But that's got nothing to do with the question of whether it's dispute resolution.
Well, that is how it was developed, my lord, by way of submission, to try and distinguish the roles of the arbiter and the expert. And I accept that there may be little in that, but it was how Inveresk developed their argument. But Lord Clark goes on to say, there is nothing, we repeat, in the language of the agreement, however, that prevents the respondents withdrawing their proposed adjustments and indicating their agreement with the figure in the draft consideration accounts, thus rendering the auditor's task of verifying and confirming it redundant.
Yes. Could I just ask a factual question? Between 31st of January and the time that the vendors
withdrew their request for adjustment, Pricewaterhouse had embarked on in some sense, on the determination, hadn't they?
They had, my lord. They'd been instructed to do so, but that in itself raised
No, but just factually.
Factually,
one can see that the correspondence shows that papers were sent to them. But I just wanted to know if it's accepted that they did some work.
they were instructed to begin the process, and then the solicitors for Inveresk took issue with what they should actually be doing, and that is reflected, if my lord allows me just one moment, in the terms of the averments at tab 8, page 176.
Yes, but my question is simply this. Were they actually doing some work?
They hadn't actually carried out any work because they wanted more precise terms of engagement, and that is where the parties were at odds.
They had considered the papers, presumably.
They had received them,
their view.
but they wanted to know what the precise terms of engagement were intended to be. And the dispute is reflected in the averments at 176B. That is at tab 8 of the core documents.
Yes.
Inveresk refused to agree the expert's terms of engagement.
Sorry, where is that?
176,
At?
letter B, my
Oh,
lord.
B, sorry.
Inveresk refused to agree the expert's terms of engagement unless, among other things, Tullis Russell agreed that the only issue for the expert to consider would be the adjustments to the draft consideration accounts proposed by Inveresk. And that is where matters, as it were, ground to a halt.
So there is an issue as to what exactly is meant by tonnage audit. Is it at the top of page 293? This being what they're supposed to carry out.
Indeed so. And I submit that there's no real issue because clearly the words acting as an expert signify is that a decision is to be made by a person acting on his own expertise rather than adjudicating between competing contentions.
Well, it could be.
Yep. Of course, you could, this is why I'm finding difficulty in seeing where on your argument this makes any difference, because you say what has to be referred is the question of the tonnage.
Absolutely.
And there might well be, leaving the consideration accounts entirely on one side, a lively dispute about the tonnage, full stop. But your case, as I understand it, is that, well, that's all very interesting, but the agreement talks about the tonnage audit. It says nothing in this contents about the consideration accounts at all.
Well, Lord, I entirely agree with that, but I'm trying to address the way in which the learned friends invited the inner house to approach this matter, and indeed invited Lord Glennie to approach it.
Well, I think I can see what the inner house are driving at. If the entire subject matter of the reference to the expert was simply whether or not the draft adjustments, the adjustments were not well founded, and you withdraw the adjustments because you no longer insist on them, then the whole substratum of the reference disappears.
Indeed.
But if it's a broader issue, which is to verify the tonnage, then the fact that the adjustments, which have some effect on the tonnage but don't tell you the complete answer, doesn't support that approach. I think that's the point you're making. You're saying the inner house misdirected themselves on this point.
And the Lord puts it very succinctly, and that is what I was seeking to arrive at. And what I suggest is that the distinction made by the inner house in MacDonald at paragraph 26, albeit one might take some issue with the way it's expressed, is directed to the same result. This is at page 54, the first column of the report, letter B. And the inner house expressed the matter this way. The words acting as an expert are normally used in legal practice in contradistinction to the words acting as an arbiter. They signify that the decision maker is to base his decision on his own expertise rather than adjudicating between competing contentions and bodies of evidence.
Could be both.
Well, it might be, my lord, but continuing, that is to say, he is to make an expert determination rather than to conduct an arbitration. Now, what I take from that in this present context is that where Inveresk were contending that all that had to go or could go to the expert was, are the draft consideration accounts right or are the adjustments right? That is wholly misconceived, although the inner house appear to have gone down that same road. Because at the end of the day, all that was being referred to the expert was determination by external verification of the tonnage. And once Inveresk had demanded that there should be an external verification of the tonnage, the fact that they withdrew or didn't withdraw their adjustments was, in my submission, nothing to the point.
So, in fact, in the passage in the inner house, Lord Clark refers to, puts in inverted commas, the tonnage order takes place to verify, inverted commas, and confirm, inverted commas, the figure first proposed in the draft consideration account. There must be a place where the word confirm is used. I just wondered if you could just remind me where that is. I see it's to confirm. It's in 5.1a.
Yes, it is.
Sorry, I beg.
So
I just
they put the thing the other way around, but
Yeah.
those two words are
yes,
both
thank
there.
you. Sorry. But they say they substitute for the words the tonnage. They put in a figure in the first proposed in the draft consideration account.
Exactly. And this also developed into what I submit was a somewhat sterile argument about whether or not there was an implied term permitting Tullis Russell to amend the draft consideration accounts.
I suppose Lord Clark, writing his sentence, might have said, looking again at what you've drawn our attention to about the auditor's task, although he said their agreement with the figure in the draft consideration accounts, the figure that we're talking about is the tonnage, isn't it? And is it possible to approach the matter in stages that the general flavour of this is if there is a reason for disputing, if the vendor is disputing the tonnage figure in the accounts, then ultimately he can go to clause 5 for that to be resolved. But is there a stage at which he can, although having initially notified that he wants to do that, he can change his mind? Or does it proceed to a stage when you would say, well, it's got so far he can't withdraw his mind? Is there any point at which he can say, sorry, I don't want to proceed with it anymore. I'd rather get my money now and just...
In my submission, if one looks at the structure of Part 3, there are a series of time limits. Now, I appreciate we've looked at how, in practice, there were difficulties with that, but there are a series of time limits to fix certain events. You can receive the draft consideration accounts and agree them. You can receive the draft consideration accounts and within the review period, you can ultimately agree them. Or you can propose adjustments and within 5 days of the adjustments, you can agree them presumably by withdrawing them all if the other side are content with that. Yes. Once you're out with those time limits, the mechanism expressly provided for, and this is simply what the parties have done, it is by way of expert determination. Now, of course, at any point prior to the production of the tonnage audit statement, the parties could, by agreement, innovate the terms of Part 3. But in my submission, it cannot be done unilaterally. The Inveresk argument began from the perspective of their right to waive the requirement for a tonnage audit. They then departed from that, and although it's not apparent to me what the difference is, they now advance the argument that they're entitled to unilaterally abandon their adjustments, thereby leaving the figure in the draft consideration accounts. Neither approach actually works in my submission. Once you have triggered the requirement for expert determination, and it was triggered by Inveresk's express determination of the point, express request, then there will be a mechanism for resolving the tonnage by way of expert determination. And yes, thereafter the parties could agree to do what they like, but absent agreement, there has to be an expert determination in order to arrive at a tonnage and a payment date.
Well, let's assume, and I know this isn't your position, but let's assume that the whole mechanism is conceived entirely in the vendor's interest. Why shouldn't he be in a position to withdraw a day after he wrote his letter and say, I've changed my mind, I don't want to proceed with this, I'd like to simply go ahead under clause 4.3.
Then you have a case of waiver. He's entitled to waive the terms of the agreement if he can satisfy the court that they're conceived entirely in his interest and benefit and not for the interest or benefit of the other contracting party. And that is the point, in my respectful submission, made in Manheath against Banks when my Lord was sitting as Lord President. The case is at tab 36 of the bundle of authorities, and the very short point that is made there is also expressed in the statement of case. But at tab 36, if my Lord has that, in the second volume of the authorities bundle, now, the facts and circumstances of the case are different, but the dicta to which I would draw attention is at page 48, letter H. The Lord Ordinary, my Lord noted, in the present case has suggested that the question of severability is better regarded as being additional to and distinct from the first question, rather than as a test by which the first may be judged. I agree with him to this extent, that it may be helpful to look at the matter in two stages, but I do not think that there can be any hard and fast rule about this. If the condition is so expressed that it cannot be said that it was conceived solely in the interest of the party who seeks to waive it, that is an end of the matter, and it will be unnecessary to look at the other provisions of the contract. But an affirmative answer to the first question will not be enough to confirm the validity of the waiver. The clause cannot be waived if it is incapable of being separated out or severed from the rest of the contract. So it is necessary at this stage to examine the whole contract. The examination may then show that, contrary to the first impression, the condition was not conceived solely in the interest of the party who seeks to waive it. And I submit that, looking at Part 3 as a whole, it is quite apparent that the provision for expert determination was not conceived solely for the benefit of Inveresk. If the parties hadn't achieved consensus or agreement with regard to the tonnage, then an expert determination involved an external verification of the tonnage. That might well produce a figure.
But only on the vendor's notification.
Only on the vendor's notification.
So if he makes a mistake, he's stuck.
Well, it's not a case of making a mistake, my Lord. If he decides to go down the route of expert determination,
I see that.
then the result may well be in the interests of Tullis Russell or in the interests of Inveresk. But you cannot say it's only going to operate in the interest of Inveresk. And again, this is where Inveresk came back to their argument that it wasn't really an expert determination, it was an adjudication about the adjustments. Because by deploying that argument, they could then say that the only beneficiary of this exercise will be Inveresk, who proffered the adjustments.
The word conceived is used, and it's commonplace, I think, in discussing this principle. That rather suggests you're looking to what the contract says rather than the result of the exercise. So one's asking oneself, was this provision there in order to benefit the purchaser as well as the vendor?
Indeed, and in my submission, it's not just the question of what the tonnage will be, it's the matter of when it's going to be determined, the certainty with which the figure will be arrived at in order that parties' respective financial liabilities can be fixed, in order to avoid the very sort of dispute that we face here.
There wouldn't be one, would there? I mean, if they hadn't notified the purchaser, then there would have been a notification under 4.5b, and equally, if they waived it, there would be such notification. So there'd be clarity there. There'd be no difficulty about, there'd be no vagueness.
Well, with respect, there wouldn't be a fixed payment date, for example, in terms of the contract. The inner house acknowledged that.
Well,
Don't understand that. I thought clause 4.5 would work in that situation.
surely this be a case in which, yes, 4.5b would operate, and then we'd know when the payment date was.
If we go back to the actual wording, my lord, 4.5b says the payment shall be in the case of paragraph 4.3b. And if we go back to 4.3b, that is the vendor notifying during the review period. And one cannot ignore the words during the review period.
Yes, but that's not a real point, is it? I mean, it's perfectly obvious that once they'd waived the... it's perfectly obvious that once they'd waived the... assuming it was valid, I have your point that it's not valid, and if it's not valid, that's it. But if there were a valid waiver, it's perfectly obvious they'd have to pay.
But there is no express provision for a payment date in those circumstances, which again is indicative of the fact that the determination provision is conceived for the benefit of both parties, not just one. If it was conceived for the benefit of just one, why wouldn't you expressly provide for a payment date in those circumstances, I ask rhetorically.
Does one get anything out of 5.3? The default position is that the costs, fees and expenses of the accountants are to be shared equally between the vendor and the purchaser.
Well, clearly, if they're both paying for it, it's because it's conceived to be a joint liability, and one might infer from that that it's both parties who benefit from the provision. If it was simply a matter of Inveresk opting for what they thought was conceived to be purely for their own benefit, why would half the cost be imposed on Tullis?
That's why I asked whether the Pricewaterhouse had embarked on the exercise, because it's rather difficult to see how precisely the waiver or withdrawal argument works once they've embarked on the process and once they have the power to determine costs.
They had the power to determine, my lord, and what they asked for was more detail as to the terms of engagement, and that's where the parties broke down, because they couldn't agree on what the terms of engagement were. Because at that stage, Inveresk insisted that their terms of engagement involved adjudicating between two figures. Could I, just on this point, touch
What
upon
you're
it?
really saying, of course, is that they're not asking for a tonnage audit at all. I mean, if they're just basing themselves on what the adjusted figures are, then it's a different exercise entirely. It isn't a tonnage audit.
Lord, I agree. If, in fact, Pricewaterhouse had done what Mr. Lake contended before Lord Glennie they would have to do, then in my submission, their determination would have been open to challenge. Because clearly what they required to do was exercise their own expert judgment in making an independent determination.
Your case, as far as I can see, entirely depends upon the definition of tonnage audit. The bottom top of page 293. And tonnage audit means the external verification of the tonnage. And that's it, really.
And that's partly confirmed by the fact that it's up to the purchaser to procure that the accountants carry out the tonnage audit. In other words, it doesn't sound as though it's something where there's going to be any argy-bargy as to what is involved. It is it's something which the purchasers themselves are in a position to, and the vendors are not going to apparently be objecting to them, simply say, carry out a tonnage audit. There's nothing, I mean, there doesn't seem to be anything which they have an input into.
Indeed, sir.
It was really up for the purchasers to make an arrangement with the auditors to get on with it, and it had nothing whatever to do with the vendors at all. Although it does seem as ever to have broken down on some point which didn't have anything to do with the contract.
The difficulty was that PwC were by then aware that issues had developed between Inveresk and Tullis Russell, because Inveresk had already attended at Tullis Russell's premises with their own accountants, KPMG, as a prelude to producing adjustments to the draft consideration accounts. And this goes back to their rights under Clause 6 of Part 3, which entitled them at any stage to come in to look at the books and records, and they had actually done that. So both PwC and KPMG were aware that issues had developed between the parties at that stage, which is why, as I understand it, PwC asked for clarification as to what their terms of engagement were.
Going back to the phrase to confirm and verify the tonnage, do I understand that your interpretation would be to confirm and verify what the correct figure should be in the accounts for the tonnage, not to confirm and verify one or other side's version of what the tonnage should be?
Absolutely, my lord.
So one reads in that that is what it is. It's looking for the correct figure, whatever it happens to be.
Well, as my Lord Clark and my Lord Roger noted, tonnage audit involves external verification, and that in itself is a guide to what is being done. It is the accountant employing his own independent expertise and judgment by reference to his own investigation to arrive at a conclusion as to what the tonnage figure actually was, irrespective of what either side thought it was.
In looking at it in the round, it would be very strange if the parties, when they entered into this agreement originally, had conceived that the figure to be paid for the additional consideration was anything other than based on the correct tonnage figure.
Well, otherwise they would have just had a fixed sum to pay at the end of the day, my lord. The whole exercise, the whole machinery is designed to fix additional consideration by reference to the actual benefit that the purchaser has gleaned from the acquisition of the goodwill and the trademarks.
Can you make the point that if what the purchaser's accountants must do is to confirm and verify, leave aside the word tonnage for the moment, and it could be said, well, how can they confirm the original consideration account in circumstances where, as far as I can see, everybody agrees it's hopelessly wrong? So another consideration for saying what they're looking at is not the consideration account, because they can hardly confirm that, but they can confirm and verify the tonnage in the sense of looking at the tonnage to discover how much tonnage there is.
In my submission, it was, if we look at Inveresk solicitor's letter of 14th March, it was a growing realisation that the expert would come out with a figure markedly lower than any proposed before that prompted them to say we're waiving the requirement.
Well, everybody made decisions one way and then the other way, depending on how it suited them at the particular moment. So, I mean, the mere fact that you can point to ways in which they've swung about from side to side, they can do the same to you. So
of course.
There's very little in that, I think.
No, but the point is, my lord, that clearly the expert is supposed to be there to determine an objective figure, not one that one part or the other has arrived at.
The idea that persuaded both the courts to date to reach a different conclusion was that they thought that the whole structure of this was based upon the starting point, which was that the purchaser was for the purchaser to decide how much he was willing to pay, and it was for him to get it right, and after that it was a question of seeing whether that figure was right. And the logic of your case would mean, would it, that the purchaser could have, first of all, have some accounts which said X, and then would he be stuck, would he? On your analysis of the contract, would he say, oh, well, now I've discovered that actually we're only liable for half of X, and so that's what we're going to pay. Well, it's not easy to fit that into the contract, whereas the underlying idea of your submissions is that we should get to the correct result for tonnage. But the parties didn't say, we agree to pay the correct amount. They had quite a complicated procedure, and it was that which I think led the lower courts. I quite understand you say wrongly, and maybe you're right to say they were wrong, but that was what led them to the conclusion that that it should be construed in the way they construed it. Well,
it respectfully appears to me that the matter is, in a sense, much simpler than that. What the mechanism provided for was that the parties could between themselves agree what the correct figure was, and if they couldn't between themselves agree what the correct figure was, they would hand it over to an expert to determine the correct figure. And that's really what
It's
it
not
amounts
as simple as that, though, is it?
Well, standing back, in my submission, that is the consequence. We either just agree the figure or we get an expert to fix it.
Commercially, they must have imagined that the figure would be somewhere,
Right.
assuming you're right, that it would be somewhere between the purchaser's figure and the vendor's figure.
Quite.
That might
That'd be the normal case.
That may have been the normal case, but that is not necessarily what directed them to the mechanism of an expert determination. It was simply to get an independent verification absent agreement.
And the tonnage, as defined at page 292 at the bottom of the page, is something that one would imagine could be determined objectively. It doesn't depend on what one or other of the parties thought the position was. It is simply stated to be the amount in tonnes which orders are received and invoices are issued.
Yes,
Do we have an example of an invoice?
I don't believe we do in the papers in the core bundle, my lord, but I'll check.
I just thought it'd be interesting to see what it is. Don't think about it.
If it's not in the core bundle, no doubt that it can be sought.
But it just struck me that it might be of interest to see what exercise we're actually on here, because on the analysis, as you've explained it to us, all the expert has to do is to look at the invoices and possibly the orders and to see how many tons of product there were. So all the person has to do is to look at what's invoiced and see whether it's product with a capital P or not.
He might want to audit the invoices by reference to purchasers' records as well, in order to verify their reliability.
Well, I suppose so, but it's got to be it's got to be about orders and invoices,
Indeed.
because that's how product is,
I agree.
this tonnage is defined.
I suppose we get some idea of what's being looked at page 332, do we, where we've got the Inveresk switch tonnage report.
This is the switch tonnage report.
Well, that's just that.
That's written by Dundas and Wilson too.
This is a sort of summary.
That is all got out, and it's the final tonnage figure. That's your final tonnage figure.
And one might infer that for each month one would want to refer to the invoices for that month in respect to that customer in order to determine their accuracy.
But the reason why you now get to so much lower a figure is because the product is different. Is that right?
It's not that it's different, it's that the figures that were produced included not only material that was sold under the brand.
Right, so that it's not product within a capital P.
Indeed, but
Not
also...
product as defined, is what
Yes,
I mean.
indeed.
Yeah.
I was misunderstanding a lot, but
Yes.
that is...
Yes.
And where do you get the definition of the products from? Is it Schedule 1 of the service agreement?
It's, if the Lord allows me a moment, product actually is defined in the asset agreement as having the meaning in the services agreement.
Yes.
That's at page 4. And then if we come on to
Page 303, they'll send you off to part 1 of the
317,
schedule.
is it?
page 317. But then if you come on, my Lord, to
Is it?
that's products,
303 defines it as
if my Lord has that,
very bottom on page 303. Products means the products specified in part 1 of the schedule.
but that's products in the plural. If my Lord goes back to product in the
Well,
singular...
product means products, as defined in the services agreement. Products are on page 303,
Yes.
and that sends you off to part 1 of the schedule.
And at page 292, it's products incorporating the trademarks.
And the trademarks are set out at page 318.
Indeed. But just on the Lord Savile's point, one comes back to page 292 in part 3 of the schedule, the penultimate entry.
Yes.
Well, where do we go from
Well,
here?
I don't want to spend very much more time on this point, my Lord. It has been made. But can I just notice very briefly the respondent's case, which is at tab D. In the case, they move away from the idea of an adjudication between competing positions, and that's apparent at paragraph 14, which is page 10, letter C of their case. But then if my lord comes on to 15A, at the foot of the same page, they say Part 3 tonnage audit is defined as the external verification of the tonnage by the purchaser's accountants. As noted above, tonnage constitutes a reference to the figure within the draft consideration account. Well, it doesn't. It's defined by reference to the consideration accounts, not the draft. But put that aside. In addition, the phrase external verification makes clear that this is a check rather than an adjudication between competing positions or an inquiry at large.
I couldn't really understand that, because if you have a cheque, the cheque could give you an answer naught.
Well, Lord, the word check comes in again and again. It's in 15C as well. A check, the limited scope of a check rather than an adjudication or an inquiry. So we've moved away from adjudication, but we haven't arrived at an expert determination. We're at some undefined halfway house called a check. And in my respectful submission, it's not apparent what that is or what it isn't. And
are they not right when they say that tonnage constitutes a reference within the draft consideration accounts? Because initially it must be that figure.
well, the defined term tonnage, but there is a tonnage figure within the draft.
Ultimately, you get to the final account.
Indeed.
But when you're carrying out the exercise, it's still a draft, I would have thought.
Well, if one's using it as a defined term, it's defined by reference to the account. Well, Lords, just finally, paragraph 18 of their case, over the page at page 12. The letter of 14th March intimated that the respondents would not insist on the adjustments earlier proposed by them and would accept the figure provided by the appellants. This is perhaps meant to be something other than waiver, I'm not sure. Accordingly, at 14th March, Inveresk neither proposed adjustments to the draft consideration accounts nor elected that the purchaser's accountants carry out a tonnage audit. There was accordingly no function for the tonnage audit to fulfil. There would be no commercial sense in requiring a procedure to be undertaken to confirm and verify information as to which there was no dispute. And in my submission, that just walks around the issue, doesn't address it at all.
And of course, I suppose you could say, well, it's a bit unreal to say that there was no dispute.
But there patently was a dispute, my Lord. So much so that parties couldn't actually agree on the terms of engagement for PwC once they asked for clarification. But this appears to be a development of their argument that it's not an inquiry, it's a check, but they don't actually disclose what a check is.
Rising out of what you just said, in fact, if we were in your favour, I suppose you would want us to indicate what we consider the terms of reference to mean, would you? Otherwise, we don't want to go on having a continual dispute between the parties as to what the expert is supposed to do. Is that, I mean, are we being asked to clarify that issue as well as resolve this?
I don't believe so, my Lord, because it may be that at this stage parties have appreciated that the terms of reference to the relevant accountant would be to determine the tonnage.
Once you've determined the tonnage, there's no difficulty in determining the consideration.
No. So clause 5.4 is then very specific.
It's just arithmetic from
You
then
get a tonnage, you get a tonnage audit statement. You're then contractually bound to incorporate the tonnage and the tonnage audit statement into the draft consideration accounts, which then automatically become the consideration accounts and trigger the payment date for the relevant sum.
But you say there's no difficulty in determining which of the relevant products on which the tonnage is to be, from which the tonnage is to be determined.
That would be a matter for the expert, my Lord.
Well, is there room for doubt about this? Because the product is defined by reference to trademarks which are all listed. I mean, there may be problems perhaps about legibility of things and so on.
I don't believe so, but Inveresk in the present action do have a declaratory conclusion as well, which they might want to insist upon if parties couldn't agree the matter. if one looks to the record,
You've got a declarator. There's a declarator. Does that relate to this?
there appears to...
It's not going on, as I understand. It's been sent off for resolution somewhere else, is that right?
Is that page 162?
Yes, my lord.
162, 163. I thought there was some reference to that having been sent off somewhere else for resolution. We're told we don't need to consider the declarator, are we not?
Lord Glennie said it.
Well, it's not a matter for the court in my submission, it's a matter for the expert, but they do have a declaratory conclusion there.
There's some reference somewhere to the declarator not being for us. It said it's gone off to... Am I completely wrong on that?
No, I recall that. Yes, it's at page 5 of the Inner House's decision, page 665, I should say, the first
I'm obliged, my
paragraph.
lord.
They say, before this court, parties were in agreement that that matter, that's the declarator, should be made the subject of determination by an alternative dispute mechanism entered into between the parties. I think that's what
Yes,
the
that's
court
what I was
has in
thinking,
mind.
yeah.
And so, I mean, that means it's not for us, it's gone off to ADR.
I'm obliged, yes.
That's very odd itself.
Is that the position we have to adopt, is it?
It would be the position to adopt, my lord, in my submission, yes.
And what was the declaratory? What were they asking for?
The declaratory conclusion concerned what was products and what was not products for the purposes of the expert determination.
Based on grades, not on trademarks.
Yes, my lord. But we can, in my submission, now put that to one side.
Yes.
My lords, can I turn from the first issue, which I asked the lordships to answer in the negative for the reasons given in the statement, to look at the second issue, which is one of retention.
Could you explain how that it remains relevant if we're in your favour on the first issue?
It ceases to be relevant if you're with me on the first issue, my lord.
That's clear enough, is it?
Absolutely.
Why?
Because if you are with us on the first issue, there will, on the face of it, be a need to proceed with expert determination, and no payment will be due until that determination has been fixed.
And is it assumed that the other proceedings will have galloped through to the Supreme Court and all that's going to happen to them?
I'm
before this one
obliged.
is,
My junior reminds me, but of course the dates might not work out. And I understand the force of that observation, because although the first action is the action at the instance of Tullis Russell, and although the proof is partly heard, it is conceivable that if it's completed and goes to Avizandum, that the obligation to pay may arise under Part 3 of the schedule before there is a determination of the Tullis action, and in any event, of course, the Tullis action could be the subject of a reclaiming motion.
Yes.
So, having instinctively said that if you're with me on the first issue, the second issue doesn't arise, I have to review that and acknowledge that, in fact, it may very well be a material issue, even if you are with us in the first issue.
Yes.
I apologise.
But on the action for the sum allegedly due under the the agreement, if you're right on the first point, that action fails, doesn't it? The claim for money due under the asset purchase agreement, if you're right on the first point, it can't succeed, can it?
Absolutely, but there may then be an expert determination which produces a figure of additional consideration that falls due and payable, while Tullis Russell still entertain their claim to damages for breach of contract.
Well, in which case, if you don't pay it, you'll be sued again, in which case you'll seek to raise retention again. But I can't see how at the moment, if you're right on the first point, the action that you're trying to defend by set-off or retention can succeed.
Well, my lord, there could be a situation in which the action at the instance of Inveresk is sisted,
I think,
pending expert determination.
Yes.
Oh, I see, yes.
The CIS
No,
then
it's-
recalled,
yes.
and an attempt made to enforce the expert determination in the present action, with a plea of retention then being insisted upon, and the same issue arising in the same action for determination by the court.
It's page 185. We have your pleas in law, I think, set out. And one of them, which I think you're not asking us to uphold, is plea 2, that since the matter's been to be referred to expert determination, the court has no jurisdiction. You're not saying that.
No.
But plea 3 does remain in play, I think.
Could result in the action being sisted and then revived once an expert determination has fixed a tonnage, which gives rise to a payment for additional consideration that we seek to retain pending our claim in respect of damages for breach of contract.
Do I understand sisted means stayed?
Indeed it does, my lord. I apologise for not
No,
clarifying.
no, I don't apologise for not knowing.
Well, Dean, frankly, if we were in your favour, what order would you ask us to make?
In respect of additional consideration, my lord, if my lord is with me on that, then the third plea should be sustained.
Where's the what page is the
The
third plea?
page 185, my lord, letter C.
So it's plea 3.
Yes, my lord.
Plea 3.
So if you win on the first issue, you're simply asking for the action to be stayed, sisted, and although in future the point about retention might arise again, in effect, who knows?
This is being assisted, is it in order that in the event of you being correct, they would come back, assuming they hadn't got, and ask for some lesser sum, is it?
Yes, my lord.
There would obviously be an amendment if the figure differs.
There would have to be a minute of amendment. The alternative would be for me to invite the court to sustain my plea, 1, and dismiss the present action as being irrelevant on the grounds that the pursuers are not entitled to payment in terms of the first conclusion, and having regard to the fact that they no longer insist on the second conclusion.
And having regard to the first plea in law, which seems to say they're entitled in terms of the agreement condescended on, which doesn't include a reference to a tonnage audit. I mean, they're relying on the earlier provisions,
Indeed, sir.
aren't they?
Indeed, sir.
So you're saying if that's their case, then it's irrelevant, and therefore the thing should be dismissed.
Trouble with that is that if the experts reach an agreement, or if it really is as clear as you say, and the answer is 168,000, and any expert's going to find 168,000, that can't be done in a month or two. In which case, when they started all over again for judgment on the experts, you then say
Retention.
you'd say retention.
Yes, that would be it. I mean,
Then you'd have to start all over again. The Court of Appeals already, the inner house already decided that. We have to come back to the inner house so that this court to decide that then.
they have no case based on the outcome of a tonnage.
No.
That is strictly correct, Lord.
Not only strictly correct, it's correct.
It's well, what I envisaged was that if there was a cyst, there would be an expert determination and there would be an amendment by Inveresk of their case in order to reflect the outcome of the expert determination.
So we would be holding, we would assist the case so in order to save them from having to raise another action for us on a different basis. Is that right? Seems a very straight, it's a very generous approach, I must say.
Lord, the thought of being generous prompts me to reconsider, of course.
Well, it wouldn't be generous at all. I mean, it would be monies due under the contract in respect of additional consideration, which is what the dispute's about.
Well, it would be, but strictly if they are not seeking to advance an alternative case with regard to the outcome of an expert determination, then my motion would be for the court to sustain my first plea and, Lord, dismiss the action.
But I don't suppose you'd be generous if there was a motion about expenses, if they had to amend their case to bring in the tonnage audit and alter the terms of the first conclusion.
Will indeed not.
That you would ask for the expenses to date.
So the result would be the same.
Much the same.
And it might therefore be appropriate that I simply move the first plea and dismissal on the grounds of relevancy.
Well, anyway, I raised this because I thought we ought to be absolutely sure where we're going. So you're saying, well, we have to look at question 2. If you don't succeed on persuading us to dismiss.
Strictly, if my Lord sustain my first plea and dismiss the action,
That's it, yes.
that is an end of the matter. Retention does not arise as an issue. But as my Lord Clerk indicated, we will then find ourselves with an expert determination, a new action for £168,000 or otherwise, and a new plea of retention, addressing the principles of retention in the context of this contract. When that issue has been addressed by the outer house and the inner house already, and find ourselves going back through the outer house and the inner house in order to come before your lordships for a final determination of the law of retention.
Say issue a stopple then, if you want.
So, with your lordship's leave, it might be appropriate that I should address retention as an issue as well.
Yes. Well, I don't think there's any doubt that you had better do that.
I think so, only if we hear
This retention point, I mean, are both sides solvent in this case?
I mean, I don't mind.
I cannot answer that in respect of Inveresk, my lord,
Construction.
but one might infer that they are, but their shares were suspended from the AIM and they are no longer listed on the AIM.
Got it in our minds.
And they have posted publicly on their website the allegation that that's due to the actions of Tullis Russell.
Well, Dean, please proceed, I think, on issue 2.
Very well, my lord. Can I just notice, my lord, that in my submission, retention is not a defence, but a form of security.
Yes.
Retention is founded upon mutuality of obligations.
Well, you've set out very helpfully in your case, I think, a sort of summary of all the various dicta on the subject. These appear at pages 22 and 23. And perhaps we don't have to look up many cases to get at the point of principle.
I wouldn't propose to take my lord through all these cases in order to vouch those short propositions that have been set out in the case. And what I would propose to do was to set out what in my submission is the relevant principle, to take the Lords to the decision of the inner house for some observations, and then to take the Lords to what I would submit as a useful summary of the relevant law provided by Lord Drummond Young in the case of Holt against Turpin, which I will endeavour to adopt. But with my Lord's leave, I do not intend to go back through the dicta which have been listed and quoted in terms in the case.
Thank you.
I simply adopt them. Lords, the underlying rationale for retention is clearly that where contractual obligations are inseparably connected, however they may be expressed, one party should not be obliged to perform an obligation which is reciprocal to a material obligation that the other party refuses to perform. And I would respectfully concur with Lord Glennie's observation that retention can operate as between such obligations expressed in separate contract documents. That was a point that he made, in his opinion, in the Outer House, tab 6 of the core bundle, page 126, paragraph 44, I turn next to deal with the question of reciprocity. Here it seems to me that the preserves are on stronger ground. I do not think it fatal to the defender's plea of retention that the relevant claims in the other action arise out of obligations under a different contract. Passage in below quoted by Lord Jauncey, which refers to debts arising out of the same contract as the debt which is sued for, should not be read as set in stone. The courts see many instances of a single transaction being made up of a number of separate contractual documents. In the case where the separate contracts are all part of the one transaction, as they are here, I see no reason in principle why the concept of mutuality should not apply to the transaction as a whole, or why obligations in one contract should not be regarded as the counterpart of obligations in another. There can be no sound reason for an artificial cut-off which dictates that retention may be available if parties put their whole agreement into one contract, but not where they put it into a number of distinct but related contracts. And as I say, I would respectfully adopt that analysis of the position as expressed by Lord Lennie. I should say that on this point, there was no cross-appeal.
No.
Although the issue did re-emerge in the Inner House, there was no cross-appeal by Inveresk on that matter. Could I then look at the Inner House opinion, which your Lordships have at tab 2?
I suppose that was a point to take in the Inner House.
Lord, if it's a point to take anywhere, because at the end of the day we're concerned with an analysis of the relevant legal propositions and principles. What I would intend to do is go directly to the decision of the Inner House on this matter, and just to, if I may, take it as read, but pick up on a number of points, beginning at page 33 of the core volume. Halfway down the page, after referring to some of Lord Rogers' observations in the case of Macari, the court continued, those remarks were of course made in the context of the court dealing with a case where there was only one agreement between the parties embodied in one single document. It was a contract of service. The starting point in the present case is to recognise that the parties have deliberately chosen to enter into two separate agreements embodied in two separate documents. Those two separate agreements have different legal descriptions. One is a contract of sale and the other is a contract of services. These nominate contracts carry with them different legal consequences beyond what the parties may themselves have expressly agreed. And then there's a suggestion that no example was given of this happening in the past. And I'll come back to that if I may. Just pausing, query what the position would be if the two separate agreements with different legal consequences, namely sale and services, were embodied in the one contractual document. And query, why is the starting point that here the parties have chosen to enter into two separate agreements embodied in two separate documents? Yes, there are two separate documents in respect of a single transaction. Everyone has agreed about that. There was a transaction, or what is admitted to be the transaction between the parties.
But they are interdependent, the two agreements, in any event, aren't they?
Absolutely, my Lord. One agreement could not stand on its own. They have to be read together. And indeed, it's interesting that later on, the Inner House, in order to construe some of Inveresk's obligations under the acquisition agreement, actually have to go to the terms of the service agreement in order to give it a meaning it doesn't appear to have on the face of the express words. And that's a perfectly legitimate approach to take if you recognise the two agreements are inextricably linked.
Well, you can't work out what the tonnage audit is without going to the services agreement.
You can't work out what the product is, my Lord,
Yes.
without cross-referencing. Indeed, my Lord and the Chair asked this morning, do we list the cross-references? They are in the statement of our case at paragraph 5, my Lord, Roman numeral 1 to 7. I won't take the Lordships to it, but if my Lord just wanted to note the reference.
Yes.
I know that English law has got nothing whatever to do with this case, but I'm pretty sure that the approach of English law has been in this kind of set-off situation to talk about claims and cross-claims arising out of the same transaction.
Absolutely. That is why you have, in English law, transactional estoppel and transactional set-off. And indeed, the Inner House are wrong when later on they go on to say that English law reaches similar results to Scots law. If Scots law is what the Inner House say it is, then they don't arrive at similar results.
The only difference appears to be the rationale. Under Scots law, it appears to be the idea of withholding performance if the other party is in breach. The English rationale for this type of case is simply it would be unjust to allow the claim to go forward without taking account of the...
It is more of an approach founded on equity, perhaps,
yes,
than common law analysis of principle. But underpinning both of my submission is the concept of mutuality and reciprocal obligation. Why should I be bound to perform my obligation if you refuse to perform what is clearly an inextricably linked or reciprocal obligation?
It seemed to me that Justice Corbett in South Africa, this is a case that Lord President Roger quoted, he said that the one obligation was undertaken in exchange of the performance of the other. And that's seems to be the civil law approach, that mutuality looks for that kind of thing. And if you look at it that way, if you're looking for obligations which are undertaken in exchange for another, it doesn't really matter where they're to be found, so long as you can see that that was the nature of the undertaking on either side.
Absolutely. And that is why, in my opening, I submitted that one is concerned with the issue of mutuality of obligation, not mutuality of contract, although the latter term does creep into the case law from time to time. In my submission, that is a perhaps unfortunate shorthand, where in simple contracts one finds all the obligations embodied in the one document. But in reality, one's concerned with mutuality of obligation. And one can see that when one works this out as a matter of principle, and indeed as a matter of equity. But I would concur with the suggestion that English law does allow transactional set-off in circumstances where the obligations, albeit they arise from separate contracts, are clearly linked. I should perhaps add that there is a short commentary to that effect in one of the tabs from Professor Good's work on transactional set-off. And I believe that's at tab 40. I lost this line. It's at tab 49, my Lord. I don't know if it's necessary to take your lordship to tab 49, paragraph 7-51.
Yes.
Page 205, the last paragraph on that page, my Lord. The editor observed, after the fact that the claim and cross-claim...
I'm so sorry, which page are we looking at of Good?
It's 305, and the pagination at the foot of the page, my Lord.
Thank you.
The paragraph number in the margin is 751. Whilst the fact that the claim and cross-claim arise out of the same transaction is not per se sufficient to establish a transaction set-off, conversely, it is not a barrier to set-off that the cross-claim arises out of a separate transaction. It is enough that it springs from transactions that are inseparably connected so that the defendant has a claim to the protection of equity, and this is even if both claim and cross-claim are unliquidated. So I accept that the origins may be different, but in my submission, the consequence is essentially the same. One is concerned with mutuality of obligation.
Yes.
Going back to the Inner House, my Lord, at page 33, paragraph 50 of the Inner House opinion. The Inner House noted, at this point, it is, in our view, important to recognise a distinction between an agreement set out in several documents which fall to be read together, and if so read together constitute one legal contract, for example, of services. On the other hand, two or more legal agreements executed between two or more parties which have their different legal consequences and purposes and which are contained in separate documents. In my respectful submission, the Inner House is moving from two extremes here. And really, the analysis does not further a proper consideration of the situation in the present case. And indeed, that is noteworthy when, having said that, they go on to quote Gloag in his work on contract, where he talks about two contracts having no connection with each other. And in my submission, nothing could be further from the point so far as the present case is concerned. Going down to paragraph 51 of the Inner House opinion, it's halfway down, page 34. The court continued, "It is, of course, always as an aspect of freedom of contract open to parties to agree expressly that the performance of obligations contained in one contract between them will be dependent on performance of obligations in another contract between them, even if the contracts are not executed at the same time or can be said to have any close interrelationship, apart from the fact of being between the same parties. That is not, however, this case." Now, I just noticed, well, it certainly isn't this case, but to take it a step further, if parties can agree that expressly, why can't they agree it by implication? Why, if it is perfectly clear from the structure of two documents that they pertain to the same transaction, can the result arrived at here by the Inner House not be the product of necessary implication from the terms of the contract? As a matter of principle, there is no reason to admit of one and exclude the other. If the Lords go on to page 35, again it's a fairly lengthy paragraph, the second half, just under halfway down.
I don't know quite how he decided how to divide up his paragraph.
Isn't recital C to the services agreement a complete answer to all of this?
Recital C, Lord,
Yes.
of the services agreement, it's absolutely clear, my Lord.
There's a purpose, it's absolutely plain from that.
I mean, it in my submission, makes it clear beyond peradventure what the parties intended. I mean, if one was looking for an express term, one more or less finds it in recital C, and if one felt that the words themselves were not absolutely clear, one could see that what was intended, what was to be implied from the recital, was the result that the Inner House were alluding to. Furthermore, there's the entire agreement clause at clause 22(2), which says when you read this agreement, if you want to understand the agreement between the parties, you read it with the acquisition agreement. They are one for that purpose. And again, it may not say in express terms, and we're going to have a right of retention, but the right of retention is in fact something that is readily to be implied and can only be excluded by the clearest possible language. That was a point made by the Inner House in the case of Redpath, Dorman Long, which your Lordships will find at tab 45. Tab 45 is in the second volume of authorities. I appreciate that the Lordships were looking here at a contract contained in one document, but it's the underlying principle that is relevant here. I won't take your Lordships in detail through the case. It was a decision of the second division. The relevant passage is at the top of page 371, first of all, where it's noted that the common law right of retention was not excluded unless it was shown in clear and unequivocal words that the parties had agreed in the contract that such right would not be available in respect of breaches of that contract.
Is Mr. Curry arguing that it is excluded?
Sorry, my Lord?
Is Mr. Curry arguing that it is excluded? I mean, he says it doesn't arise.
He says it doesn't arise.
Yes.
I don't think he says it would arise, but it has been excluded.
Well, I agree with you. Lord, but what I think to illustrate was how generally the right of retention is assumed to arise and is not readily excluded, and to come back to the way in which the two documents are connected by the recital and the entire agreement clause, amongst other, and how one would readily infer from the terms of those references and cross-references that the right of retention did operate in respect of the obligations undertaken with respect to this single transaction.
Well, I don't think their lordships require very much persuasion for the moment that the two documents are closely related to each other and one has to read them together. The question really is, and it's the same question that could arise if there was a single contract, which is whether the obligations which you're complaining about as not having been fulfilled are truly reciprocal to the obligation which the vendor is trying to enforce. We've got the envoy trying to obtain payment, and you're complaining about failures. I think I'm right in saying it under both agreements. You've got a complaint under the asset agreement, and you've got a complaint under the service agreement. And they're all to do with the point you'd addressed at us earlier about maintaining the value of the asset, both before and after the beginning of the relevant period. Now, how does one address the reciprocal nature of these obligations?
Well, I will just come on to that. If I can just make one observation, Lord, the Inner House are clearly wrong then in their conclusion that there could be no right of retention, however mutual or reciprocal the obligations appear to be, as between obligations arising in the two agreements.
Where do they hold that?
Essentially, my Lord, at paragraph 53, halfway down page 36.
They intended to keep these documents separate, really, is the point they're making. It's about 8 lines from the bottom, the intention that because they kept the documents separate and they didn't have a cross-reference between the two, then they must be taken to have intended that retention should not operate.
Indeed, sir.
And that really is, as I understand it, the ratio at the end. So it works on, first of all, by saying, well, this is the idea of having a retention between two separate contracts of different nominate characters is odd. And then the absence of anything to show that retention was actually intended defeats the claim.
And because the Inner House are of the view that there is a strong, at the very least, a strong presumption that the intention must be that the obligations contained in these two separate agreements were indeed independent. And that is at the foot of page 35 of the Inner House reasoning. It's the last 8 lines, my lords.
Yeah.
It seems to us in any case that matters are to be determined by having regard to construing what the intention of the parties was, by what they've said and done, and the fact that they chose to execute their agreement in 2 distinct legal agreements raises a strong presumption, at the very least, that their intention was that the obligations contained in these 2 separate agreements were indeed independent and not interdependent. And I submit that that is simply wrong.
I think that if they were here to defend themselves, they'd say, wouldn't they, that the respective obligations were not dependent one upon the other, even if, and that would be the case even if they were in the same contract.
Yes. That's why I said earlier that I think you've got to address that point, actually, because that's quite a difficult point, which I think one can see in other cases has caused courts really quite some problems.
Well, indeed.
How are we to determine that?
One then has to address, of course, the requirements, which are not just for mutuality or reciprocity, but also that there should be a material breach. I just noticed that the respondents in their analysis of retention make no reference to material breach as a feature of retention, which is somewhat surprising given the legal dicta to the effect that that is the control mechanism for retention. It doesn't always operate, material breach is required. Now that's relevant because instead of placing emphasis on material breach as the control mechanism, the respondents in their written case seek to stress the fact that you shouldn't allow retention between separate agreements. So they look elsewhere for their control function.
I mean, how does that arise in this case where you've got, I mean, you're claiming to set off, I mean, a huge sum of damages, are you not?
My position, my Lord...
Obviously would be material on any view, if right.
My position is that Inveresk were clearly in material breach of their obligation with regard to preserving and transferring the goodwill, which was part of what had been purchased and was to be paid for. As a consequence, they seriously damaged that goodwill or customer connection, and that loss has been measured at a sum approaching £5 million. As against that, the learned friend's argument coming to the issue of mutuality is, well, that's got nothing to do with the services agreement, which merely provided that we would manufacture for 5 months and be paid £5 million and use the coating machine for 5 months and be paid £3 million. But to put the matter very shortly, first of all, what we were acquiring in terms of the transaction was the benefit not only of the trademarks, but of the goodwill that attached to those trademarks. And the object of the services agreement, as recital C makes perfectly clear, was to try and ensure that as much of the goodwill could be successfully transferred to the purchaser as was reasonably possible. In other words, they wanted to maintain the customer connection.
I know it doesn't arise in this case, but could I just ask, under Scottish law, what are the control mechanisms for ensuring that perfectly valid money claims are not delayed by spurious claims to set off?
That, first of all, there must be a material breach of contract by the other party. Lord Drummond-Young, in the case of Holt against Turpey, points out that that is perhaps the most significant and important mechanism to have regard to. It should be noticed that, although it may be incidental, that Tullis Russell raised their action first. The Inner House are wrong about this, for damages. Then, in the face of that action for damages, Inveresk raised their action for payment.
I was really only asking what are the procedural control mechanisms.
I would say that in this context, my lord, the requirement that there should be material breach.
And prima facie case or something like that?
At the very least, my lord, yes. And of course, in the context of diligence in general, there is now, with regard to convention rights, the need to ensure that even before an application is made for any kind of diligence, a case is made out. In the face of a dilatory defence, there is then the mechanism of summary decree, whereby the pursuer, the party seeking payment, can come into court at any stage after the initial process has begun and move the court to grant decree on the grounds that no defence is stated, no defence is available, or even that a defence stated has no substance, having regard to material that can be placed before the court. So there are all these control mechanisms available, my lord.
It's put quite well in the passage at the end of Lord Drummond-Young's judgment, which is quoted in paragraph 53 of your case. I think it's page 26 of your case, and it's the quotation from Holt against Turpey, where I think he's addressing this very point. It's really the last sentence. If the misperformance is substantial and therefore threatens to deprive the employer of the practical benefits of the contract, that can be regarded as a threat to future performance and would amount to a material breach for these purposes. I think is that really your point here, that if you look at the purpose of this contract, which is to maintain the connection with customers, that's why the money was being paid over to them under the additional consideration.
Indeed.
And that would be really deprived of its value if there's a breach which actually undercuts the whole point of the connection in the first place.
And then one takes it a stage further and arrives at a point 12 months later where they say, and we want to be paid the balance of the price that you are giving us in consideration of the assets, which in the meantime we've severely damaged.
Yes.
Well, it's just like a contract for the sale of goods. If you set up a warranty, a breach of a warranty of quality, in breach of the contract, then you're entitled to set it up against the price.
Indeed.
Well, is there much more that we need to say about this? Do you think we've...
I should perhaps at least identify two matters fairly shortly. One, the relevant terms of the contract. We've touched upon those already.
Yes.
But I should perhaps just look at them briefly.
Right.
If we begin with the acquisition agreement at tab 11, in order to identify the relevant obligation that's founded upon there, it's at 15.4, page 278.
So this is a provision that's found in the very same contract as the additional consideration is due under.
Absolutely, absolutely. Interestingly enough, the Inner House construed this clause as only applying in respect of goods manufactured before the commencement of the service agreement period. On the face of it, that's not what it says, so they construed it by reference to the further provisions in the services agreement period dealing with the goods manufactured during the services agreement period, which may be perfectly legitimate, but just underlines how the two documents are inextricably linked.
Yes.
Now, even if this only applied to goods manufactured before the service agreement period began, that's of little materiality, because the issue that arose here and the damage to the goodwill and customer connection arose largely not because of the defects in the manufacture of the goods, but because of the manner in which Inveresk then dealt with the customers who complained about that. And that applies equally to goods manufactured before the service agreement as to goods manufactured during the services agreement. And indeed, merchants and printers were not determining whether the goods were manufactured before or after a particular date of which they had no knowledge on the face of it. They were simply concerned with the manner in which they were treated. So 15 Stock 4 is relevant to the claim. Now, when I say the claim, I acknowledge this much, my lord. Tullis Russell advanced what is termed a global claim for loss of profit. But they say that each contribution to that global claim can be laid at the door of Inveresk. Some of it is 15.4 breaches, other breaches are breaches of clauses of the services agreement, but each of them can be laid at their door. And it can be no answer in my submission to a plea of retention that you have a global claim that doesn't distinguish between the direct effect of one breach of contract and another breach of contract. Indeed, as a matter of law and as a matter of generality, the test for breach of contract is that the breach was an effective cause of your loss. It doesn't have to be the only cause of your loss. It doesn't have to be the most effective cause of your loss. So it's quite sufficient for the purposes of retention for Tullis Russell to point out that an effective cause of their loss was the failure of Inveresk to temper their obligations under clause 15.4 of the acquisition agreement. And that's even before we get to the services agreement. The answer to that from the Inveresk point of view was, well, we don't know how much money was involved in the 15.4 breaches as opposed to the other breaches. It's a global claim. The entire loss is attributable to their breaches of contract, and the fact that their breach of 15.4 was an effective cause, and that's what we plead, is sufficient in my submission.
Could the breaches of which you complain have had the consequence that had they not taken place, the tonnage would have been more?
Yes, my lord. That, of course, is then met with the suggestion that that wasn't the purpose of it. Of course, the obligations to maintain the goodwill went much further than just the determination of the additional consideration. But clearly, the manner in which customers were treated would have an impact upon the sales during the ensuing 12-month period after the end of the services agreement for the calculation of tonnage. And it would have a deleterious effect. It would potentially reduce
yes,
the tonnage.
What I was getting at, and I may well be wrong, is that you say there's actually, or may be, a fairly close connection between the tonnage calculation, i.e. your first point, as to what the tonnage is. And could it not be said by your opponents, I'm not sure they would say this, but they could say, well, if you look at the consequences of our breach, assuming that to be taken place, one of the consequences would be that but for the breach, the tonnage would have been much higher. If the tonnage would have been much higher, you should be paying us more, and therefore the damages must be adjusted to take that factor into account.
Well, in my submission, that is taking far too narrow a view of the matter. We were concerned not with the sales over a 12-month period after we acquired these assets. We were concerned with a transfer of the goodwill, the customer relationship that we were
Well, I was
paying.
actually putting the point as one in your favour, in the sense that there is or could be a very close connection between the consequences of the alleged breach and the tonnage that might otherwise have resulted.
I agree with that, but what I say is that clearly what one was concerned with was the value of the goodwill over a longer period than just the period for determining the additional consideration. But there is a linkage, clearly, between these obligations and the sales that then ensue during the 12 months after the end of the services agreement.
You have an averment, actually, which I thought was making the point that Lord Savile's made at page 550, which is in the closed record in your own action. It's tab 25, and it's in statement 9, page 130. And I thought the second sentence there, the pursuer's actions, is it the pursuer's actions, had the effect of reducing the tonnage and thereby the additional consideration. Is that the same point?
My Lord, that's the counterclaim.
Oh, it's a counterclaim, I
action.
beg your pardon. But that's why it's a statement rather than an article. Yes. I see.
This is Inveresk
Yes.
claiming that the way we dealt with customers
see.
somehow reduced the tonnage.
Right, I'm sorry. Yes, I follow. Yes.
Lord, I've dealt with the term in the acquisition agreement proper at clause 15(4), and I don't seek to elaborate upon the point. In my submission, it's perfectly apparent that a breach of that obligation would, on the face of it, give rise to material damage to the goodwill which was being acquired and paid for. And the whole purpose of the consideration was to pay for that which was being acquired, and that which was being acquired clearly included the goodwill attaching to the trademarks. Moving to the services agreement, and the Lords are already aware of recital C, and I don't revisit it at this stage, but the obligations there at clause 2, in return for which payment is to be made under clause 3, include 2.1b to implement an incentive scheme to motivate the employees to maximise the sales of the product. Or C, to use all reasonable endeavours to protect the trademarks, maintain the existing levels of customer service to purchasers and potential purchasers, and to promote the successful integration of the owned intellectual property rights into Tullis Russell. E, to maintain continuity of manufacturing and conduct its business in the ordinary and usual way so as to maintain the business relating to the products and the licensed products as a going concern. My Lords, in my respectful submission, that is what Tullis Russell were paying for. That is what the consideration and the additional consideration were for. At 5.1, standard of quality. And there were then quality standards specified. And there was a breach if the product didn't conform to the quality standard.
When you say paying for, one has to bear in mind 3.1, of course, which looked at alone suggests that the payments we see set out there are in respect of the undertakings in this agreement. So you've got to get beyond that.
My Lord, in my submission, one cannot readily take out the value of the goodwill and in the context of the services agreement, assert that the obligation to protect the value of that goodwill was merely reflected in the payments made under the services agreement. This is where the two agreements become inextricably bound up with each other.
You say some of the consideration is in the other agreement, is that what you're saying? Some of the consideration is in the other agreement, is that what you're saying?
If
It's very strange.
The assets acquired embrace the goodwill and customer relationship. As recital C of the services agreement makes clear, the object of the services agreement is to preserve that and ensure its optimum transfer to Tullis Russell.
It is quite tricky, though, isn't it? I mean, you've got a lock on both sides, as it were, of the clauses in clause 2.1, which you're talking about, because it says, in consideration of the fee identified in clause 3 below, the undertakings are given, and we see B, C, and D that you refer to, and then when we get that sort of phraseology again in 3.1, in consideration of the undertakings, this is the fee. Now, we've got the purpose, of course, which is set out in the beginning of 2.1, but as it were, the vice, which is locking together the undertakings, together with the consideration in clause 3.1, is fairly plainly set out.
Just to take an example, if I may, in responding to my Lord's observation, if one turns back to clause 913 of the acquisition agreement, page 272,
Nine,
1.3,
1.3, yes.
the vendor's maximum aggregate liability under the warranties is limited to the sum of £13 million plus an amount equal to the amount of additional consideration, if any, paid by the purchaser, provided that in assessing the vendor's maximum aggregate liability and the loss or damages suffered by the vendor as a result of any breach of the warranties or any of them, full account should be taken of the sums paid by the vendor to the purchaser in terms of the services agreement. In other words, again, when you look at the wording of the two agreements, it's apparent that the maximum liability, or the cap for breach of warranty, is the totality of the sums paid under both agreements, which is £13 million plus the additional consideration, which takes one up to a maximum of £15 million. So when there is a reference to consideration for particular obligations, the terms are used rather loosely within one agreement or the other. What the parties had in mind was a total consideration of £13 million plus the sum of the additional consideration up to a maximum of £2 million.
Yes.
The warranties are defined as the warranties contained in Part 4 of the schedule.
But in fact, what appears at Part 4 of the schedule are the owned intellectual property rights.
Yes, do we know what the warranties are then?
They actually appear at Part 2, my Lord, not Part 4.
Oh, I see. So,
Again, it's a drafting error.
Yes.
Page 282.
yes, I see. Just a drafting error.
But there could, for example, be breaches of obligations regarding intellectual property rights or confidentiality. And there, the breach is subject to a limit on liability, a cap, which embraces the totality of the payments made between the asset acquisition agreement and the services agreement.
Yes.
Well, moving on slightly, with regard to the obligations founded upon where breach is complained of, if one goes to 312 in the services agreement, clause 14.7, it's perhaps appropriate to look at 14.6 because this is where the real difficulties arose. Inveresk shall indemnify and keep Tullis Russell indemnified against all losses and expenses incurred by Tullis Russell and arising from customer claims to the extent that the aggregate value of such customer claims exceeds £200,000, Tullis Russell shall consult with Inveresk in relation to any customer claims and shall act reasonably in considering Inveresk's suggestions and keep Inveresk reasonably advised of the progress and settlement of any customer claims, provided that Tullis Russell shall not take or refrain from taking any action if to do so would, in the opinion of Tullis Russell, materially prejudice the goodwill of Tullis Russell or materially adversely affect Tullis Russell's relationship with any customer. It was breaches of these obligations that led to the application and granting of interim interdicts against Inveresk, because the way in which they were directly approaching customers and dealing with them.
Yes.
And then a clause that I'd mentioned before, 16.2 paragraph D, the obligation to maintain the goodwill, which arises under the services part of the agreement. And again, a breach of that obligation is pled and relied upon, and a breach of that obligation materially damaged the value of the assets which had been acquired, namely the marks, the associated goodwill, and the customer connection with the associated goodwill.
Now, are these undertakings of the kind referred to in 3.1 at page 306?
No, my lord, because at 3.1 the reference is only to the life of the agreement, whereas 16.2.4 is not so limited at all. I'm sorry, 16.2d. It refers to any time after the completion date.
Yes.
So clearly, one cannot say that the 5 million relates to the obligation at 16.2d. Now, if that obligation does not have as its mutual or reciprocal obligation the payment of £5 million, what does it have? In my submission, the value of the assets for which consideration is being paid, and that includes the payment of additional consideration.
There's a rather odd provision at 16.1, first line. In consideration for the payment of £1.
I rather think, my lord, that this is English drafting slipping into a Scots contract, where, of course, there's always the greater concern with the availability of consideration or otherwise in respect of any obligation, and therefore the £1 sign appears throughout these agreements. It's of no relevance to a Scot where consideration is not a necessary requirement. But that's not the only place where one sees that emerging, my lord.
No.
And the term consideration should not in any event be confused with counterpart. It has a distinct meaning. My lords, finally, I should mention the breaches of contract that are complained of, because I summarised them in opening my submission, but I would not intend, unless my lords wish me to do so, to stand here and read at length a series of fairly lengthy averments, but what I would do with my lords' leave is simply give a reference to the record and the averments in the record which are relied upon, so that the lords have these.
So this is tab 25.
It is tab 25, my lord.
Yes.
And as I say, I can read them at length, but it respectfully appears to me that my lords have them.
Yeah.
And it is merely to draw to your lordship's attention where the relevant complaints of Inveresk conduct can be found.
Yes.
And they are at 22C to 23D. And these are marked by reference to the pagination of the record itself in the lettering. 22C to 23D, 24B to C, 26E to 28D, 28E to 29E, 34D to 35B, 37C to 38A, 38E to 39A, 39E to 41A, 41C to D, 42E to 43C,
Sorry, 40.
42E, my lord,
Thank you.
43C,
Thank you.
and 51E. And there, my lords, Tullis Russell complain of a series of material breaches of Inveresk contractual obligations, giving rise to material damage to the goodwill and customer relationship of the brand which had been purchased. Each breach, whether it be clause 15(4) of the acquisition agreement or of the obligation specified in the services agreement, was an effective cause of the loss complained of. And I submit that looking at the transaction as a whole, it is perfectly clear that Tullis Russell's interest in the value of those assets is mutual to or reciprocal with Inveresk's interest in the price of those assets. Inveresk, having materially damaged the value of those assets, and now demanding the final instalment of the purchase price payable for those assets, can relevantly be met with a plea of retention. And it would, in my submission, be an astonishing outcome if Inveresk could take the final instalment of the price and leave Tullis Russell bereft of any security for the damage done by their breaches of contract to the very assets for which they're being paid.
There's no suggestion that their virgins had an opium or any of that kind, is there?
A number of applications have been made for security and they have been refused.
Sorry, applications by whom?
Tullis Russell have applied for security on the grounds that Inveresk are not in a position to pay their debts. One example was the payment of redundancy payments which were due or overdue to certain former employees. It was disputed as to whether, in fact, they were unable to pay their debts or had made an arrangement to defer payment.
So the courts or tribunals have refused to order security.
They have.
Yeah.
So the only security available at this stage to Tullis Russell is retention.
Yes.
If I don't answer my Lord's question directly, it's not out of disrespect, but because Tullis Russell do not accept that they are not, that Inveresk are not Bergen's Adenopium. The Lords, in these circumstances, I would submit that the true issue is whether there are reciprocal or mutual obligations, whether Inveresk are in breach of those reciprocal or mutual obligations. And whether those obligations were exigible contemporaneously, upon which there doesn't appear to be an issue.
Not so much whether they are in breach, as whether there's a prima facie case they're in breach, or what's the what would be
That we
the
have
test?
made a case
Yes.
that they are in
Yeah.
breach. Indeed, so, my Lord, I accept that. And in these circumstances, we are entitled to the plea of retention.
These are the issues, are they, which are presently subject to trial in the other action?
They aren't law. There has been already quite substantial evidence with regard to the breaches of contract, and the issue that remains for trial is the measure of damages that are claimed. Subject to such evidence, I see my learned French 80 century, subject to such evidence as Inveresk may wish to lead. But I say that advisedly because a substantial body of the evidence already led by Tullis Russell was not the subject of challenge.
If the strict conditions of retention were not fulfilled, would the court in any event have a discretion to assist the money claim pending the outcome of the
No.
indemnity?
So it would become due and payable.
Yeah.
Or stay,
I
yes,
think
or
that-
stay execution, probably, I suppose, in English law it would be, rather than stay the action.
There would be no basis for a stay, as I understand the position.
I think I'm right in saying Scots law takes a rather harder view than English law on things like whether you can have an order for performance and that kind of thing, that if under the nature of the obligation is immediately due and prestable or payable, then that's it. The court simply has to declare that that is so and grant decree.
Indeed, sir.
What is the plea that we would be looking at on this branch of the argument? I wasn't entirely clear looking at page 185 in the record. Is it, you're saying it's the last one, entitled to retain until, I see, yes, it would be. You're not asking us to sustain plea 5, which is because they're in breach. You're
No, my Lord, I would
entitled
move my Lords to sustain the seventh plea in
to
law at this
seventh
stage.
plea.
That is at page 186, letter
Yes.
B.
Yes.
So this is page 186.
186.
Which action is this?
This is the action at the instance of Inveresk against Tullis for payment.
The defender's plea in the present act, your plea in the present act.
It is my plea, my Lord. Or essentially, it is my plea of retention.
And that means, in effect, it's assist, is it? I mean, if that plea operates as it's said to be, one would have to await the outcome of the other action.
Before the matter
And
could be
at
resolved.
that point, the amount due would become liquid, and then one would be in a position to understand how much is set off against the liquid claim in this action.
Precisely so.
But that can't quite be the order we could make, is it? Because the question of entitlement to payment is still subject to determination.
Well, my Lord, the plea is worded in that way because the defenders in the action at the instance of Inveresk rely upon their stateable basis of claim in their own action.
What you're saying in that plea is you're entitled to retain these monies unless and until the
I go back to my opening observation, my Lord. Retention is not a defence, it's a form of security, and that is what we're pleading.
So the action, you can't obtain an absolvator.
No, my Lord. The fifth plea in law goes too far.
Yes.
That is why I move my Lords to sustain the seventh plea in law.
I feel sure it's because I don't understand the ways of these things, but you're not entitled to payment, are you? Because that is a matter to be determined. And if we just read this paragraph 7, if this court were to grant a declaration in those terms, that would suggest an entitlement. The most you can say is you're arguably entitled to it or something of that nature.
Yeah.
Well, it's on the state of the averments, on the averments you're making.
It perhaps should read the defenders.
I mean, I quite agree it's your case.
Yes.
But you aren't seeking in this action to establish an entitlement to payment.
I take my Lord's point. It should perhaps read the defenders having a relevant claim to payment by the pursuers.
Well, if that form of word sufficiently discharges the burden of proof you have to, a standard of proof you have to establish, then so be it.
I think relevant means that you're not actually proving anything for the time being. You're simply looking at what is averred and assuming that if you are able to prove everything that you've set out,
Then I'll be entitled
then
to
you
payment.
would be entitled to payment. But it simply narrates, in effect, that one's looking at what is pled in
not
the
what is
action rather than
proved.
what is proved.
Indeed, sir.
But does it lead to assist? I mean, would it follow that the action would have to be assisted until the outcome of the other action is determined? So what is the court to do with the case?
I don't see why, my Lord, it should lead to assist. It would depend upon the timeline of the action, but even if
The actions be consolidated under Scots law.
they can be, my Lord, and unfortunately what happened here was that Tullis Russell raised their action, but instead of there being a counterclaim, Inveresk raised a separate action, and they have never been conjoined.
But I may be misunderstanding the position, but if this plea is sustained, then nothing can happen in this action until the other action is determined.
Until it is finally resolved.
So this action we're lying in the general department on the shelf, so to speak, with no label attached to it as to what's to happen next. I mean, is assist not the easiest way to identify what's happened? The action is assisted meantime, and then the assist can be recalled when the appropriate stage is reached.
Well, if your lordships answer the first issue in favour of the submission that there should be expert determination, then
Yes.
inevitably the action would be assisted,
That's right.
if not dismissed, pending expert determination. So if you're with the appellants on the first issue,
You wouldn't need another assist.
the action would disappear if it was dismissed as irrelevant. But your lordships would have opined on the principle of retention.
Yes.
If your lordships were against the appellants on the first issue, but were with the appellants on the second issue, then the commercial court may well assist this action pending the outcome of the second action in order to allow for the plea of retention that has been sustained.
But maybe it's enough for us to simply express a view, and it would have to be returned to the inner house to proceed as accords.
Indeed, sir.
And that sort of argument can take place there.
And they would then refer it back to the commercial court. on
Yes,
the
I
matter.
see.
It's a slightly odd plea, though, if I may respectfully say so, plea 7, the way it's put. Because you say the defenders are entitled, until the sums have been paid, to retain any sums found due to the pursuers. But I thought the whole point of retention was that the money wasn't due. I mean, it wasn't. I mean, the whole point of it, as I understand it, is
mutuality.
it suspends the thing.
It
says, well,
suspends any obligation.
it suspends the obligation to pay. I mean, it may come to the same thing in the end, but it isn't. I think it's odd. And speaking for myself, I know it's 4 o'clock, so I found that, I mean, the way you talked about the interest, Thomas Russell's interest in the value of the assets is reciprocal to Inveresk's interest in the price of the assets. I sort of understand that, but it's not the way that the doctrine of set-off or retention is put, usually. I mean, how do you exactly say, I mean, you say, in having damaged the value of the assets and demanding a price of those assets, because they've done that, their claim can be met with retention, as I understand. That's how you put it. I may have noted it down slightly wrongly. I mean, how exactly is that argument focused in the in the authorities. I mean, everyone else seems to have read everything about these authorities. I haven't, I confess. So I haven't even read Lord Jauncey recently. So, I mean, I just don't remember the finer points of them. In fact, how does that fit?
We have an obligation to pay the price of the assets.
Yes.
Inveresk have an obligation to pay us damages for the damage they've inflicted on the assets.
Yeah.
We submit that the obligations are mutual or reciprocal, and they cannot, in the present circumstances, demand satisfaction of the price.
Well, I mean, the reason that they would have to pay damages would be because they had damaged their assets. The reason you have to pay the price is because you bought them. Now, I'm not saying that you're wrong, but I don't see, there may be another way of expressing the link, but I don't quite see it as reciprocal. I mean, that's what I'm getting at, really, in fact.
Well,
Maybe
I
you
agree.
would prefer to think about it.
I mean, there is ultimately, when the amount of the damages are assessed, you've got a liquid sum and another liquid sum, and then the question would be whether you can set the one off against the other.
Indeed.
Now, we would be applying the same principle at that stage, but the situation becomes clearer when you actually have liquid sums. But for the time being, you're saying I'm not to be obliged to pay a sum which is already liquid because of the potential of claims being established which would give me that liquid sum ultimately when found due.
Yes, one difficulty I have is my inability to read my junior's handwriting, my lord. I wonder if my lord will allow me just a moment. What's that supposed to say?
Yes, I would.
No, what does that say?
Just for briefly.
Yes.
We have to pay the purchase price, amongst other things, in return for Inveresk transferring assets that include the goodwill. They're refusing to transfer the goodwill because they've impaired it. We're therefore refusing to pay the balance of the price because what we're receiving are impaired assets.
Well,
our obligation to pay for the assets is reciprocal to their obligation to deliver them unimpaired.
But at the end of the day, you have to pay them their measure of damages. They have to pay you any measure of damages you establish, less the amount of the price, which is determined at this expert's, if there is to be one's, determination.
At the end of the day,
That's
yes.
the way it works.
Yes.
once you know the figures.
Yes.
Once you know the figures. I would have thought myself that if it would be on the hypothesis that you were right on both these points, it would be possible for the parties to agree the appropriate form of the order, at least. I do see that agreement doesn't seem to have broken out much.
Not in this case, my
But
lord.
that would seem to be quite a limited aim in terms of...
Well, Dean, in fact, I'm going to suggest, in view of the hour, that you might like to reflect on Lord Rogers' point, and
I shall do that,
hope you won't
Lord.
take up very much time, because Mr. Curry's
I don't
anxious to
anticipate
get
I
to
will be
his
at
feet.
all long with the point, but if I might be permitted the opportunity
it's my
to
fault,
consider it.
Dean, in fact, it's just how one formulates it. That's all.
Yes. Well, we look forward to that first thing tomorrow at 10:30, and I take it there's enough time to complete the argument tomorrow.
I would expect certainly that will be the case.
Very good. 10:30 tomorrow morning.